But across Africa's data protection framework, accountability, I'm just going to read my introduction here. Accountability is not merely a principle, it is the foundation upon which lawful processing rests. Yet, in practice, many organizations continue to approach accountability as documentation exercise rather than a demonstrable lived reality. Policies are drafted, registers are created, and compliance is often reduced to paperwork. But the critical questions remain: can organizations prove that they are compliant? Today's conversation seeks to move us beyond theory into practice. We are privileged to hear regulators from South Africa, Tanzania, Uganda, and Zambia to share their practical experience of what accountability looks like from a supervisory and enforcement perspective. What do regulators expect to see when they walk into an organization? What evidence carries weight? And what are organizations constantly falling short? And importantly, how can data protection officers and compliance teams build programs that are not only compliant on paper, but defensible in practice? To start off the um, the conversation, I'll give each panelist some opportunity to introduce themselves, to let us know uh, which organization do they come from, and just a brief background that they would want the audience to understand about them. So I will be biased towards my mom, my South African mom in courts, for you to start, or to honor ladies, is most of the panelists are gentlemen, and ask Advocate Pansy to take it first, and then we'll go to Mr. Barker and then Mr. Likando. Over to you, Advocate Pansy.
Thank you very much, Alan. I don't know why do you have so many men on this panel. But my name is Pansy Tlakula. I am the chairperson of the Information Regulator of South Africa. The regulator is one of the few globally that have a dual mandate. We are responsible for both data protection and the right of access to information. And because the two rights balance each other, it's a pleasure for me to be here. Thank you.
Thank you, Advocate. Can we have Mr. Barker take it up, sir? Over to you.
Thank you. Greetings to you all. My name is Beka Vidikujja. I'm the National Director at Uganda's Personal Data Protection Office. It's the regulator. We implement the Data Protection and Privacy Act and its attendant regulations, plus also enforcement of the same. We are happy to be here. Sorry, I'm happy to be here, and I'm glad to reconnect with my colleagues from the rest of Africa. Thank you.
Thank you very much, sir. Mr. Likando, take it away, sir. Over to you.
Thank you very much. My name is Likando Luywa. I'm the Data Protection Commissioner of Zambia. I'm glad to be part of this discussion. We enforce the Data Protection Act, which came into effect in 2021, and the Commission came into effect in 2023, and now we are on the journey.
All right. Thank you very much. Say, before you go, I will start with, I'm going to pose a question to all the panelists. This question is applicable to all the three panelists on stage. I'm going to ask, when you walk into an organization or when you carry out an assessment, what are the top 2 to 3 signals that tells that accountability is truly operationalized, not just documented? Is it about documents? Is it about behavior, responsiveness, or something else? What is it that the privacy officers or the DPOs on the call can say if you are to assess them today? These are the things that will show them that they are operationalizing compliance, not merely documenting it. I'll start with Mr. Likando, then Mr. Baker, and then Advocate Pansy, in that order. Please answer the question.
I think in my view, what's more critical when I walk in is to look at the commitment that the institution has put in, and that comes out from the way management has really handled data protection related matters. And these are things to do with, for instance, the level of awareness. Did it start from the board, and how many people within the institutions have been trained, and to what level really is the DPO being supported? Those are the critical things that I would really look at.
All right, thank you, Mr. Baker. Take it away. What I pick from you, Mr. Likando, is that training is very important. It's part of demonstrating compliance. Yes, Mr. Baker, please take it away, sir.
Thank you. On our end, we have a methodology that we use. We look out for the intent. Intent, we always look at the policies, what they say, starting with if they have channels which they use to collect the personal data, say a website. We look out for whether that website actually has a privacy notice, for the commitments around how that data will be collected, who will collect it, and even how it will be protected, amongst other areas. And then also the other channels, if it has a reception, if there is a privacy notice as well at the entry of the office, talking about the same. And beyond the intent, because we've noted that documents are well drafted and intent is properly provided for, then we actually go to the implementation of the intent. So when we go in to conduct audits and inspections, what we look out for, we ask any random person within the organization, as long as they're within those premises, one, if they know who their data protection officer is. And you'll be surprised that actually in most organizations that we go to, they don't know who the person is. So that definitely we are able to tell that, they could be having these documentations and indicating the intent, but actually when it comes to the implementation, it's not there. But we also, the third point that we look out for and is around the effectiveness, because you could have the intent in the documents, then we also check its implementation, but effectiveness. And this one, we usually use it when we are checking for, in case someone is exercising their data protection rights. So asking for, in case I need a copy of my information, data that you actually collected from me, if I'm a former employee or even an employee. Let me say you handled a report to do with my background checks before I was onboarded, and I asked for that copy. Am I able to get it? What do I follow? So that's how we are able to look at it, by looking at those three areas which we've been able to document in our audit and inspection manual. Thank you.
Thank you very much. I'll give it out with Pansy to wrap up this line of questioning, and then we can check it. We can conclude from there.
Well, thank you very much. Being the last, really, you find that most of the points that we want to make have already been made. There's feedback, so I'm not sure where it comes from. But one of the interesting things also that you look at is, as you enter the building or the office, you also look at, in addition to everything that has been said, if there is, for instance, a surveillance camera, is there a notice which informs people that their personal information is being collected and what will be done with it, which is the privacy notice. You also look at the amount of personal information that they collect, because in offices, you find that as you enter, they require all sorts of personal information, including, in my country, IDs. Sometimes this personal information is recorded on a book, and sometimes it is in a gadget. And just there, as one of my colleagues says, you also ask, if you ask just randomly the security person about why they are collecting that personal information, what they do with it, they will never be able to tell you, because training does not even start, at that level, because everyone has to be trained. What tends to happen is that only people at high level are trained, and yet you find that people like receptionists, they collect personal information of people who come into the building to visit or to do whatever business. So it's all that, and in addition to that, of course, you go to documentation, implementation, and with documentation, you can't wing it, as young people would say. That you can't just wing it. You by just compiling those documents, and you don't look at the implementation of those documents. Sometimes it's not even the implementation; it also comes to the monitoring of the implementation. And then I give you a concrete example of policies, frameworks, procedures that look good on paper, and yet they are not implemented, and even the implementation is not monitored. This is a practical example of one of the companies that we assessed, where they had a very good and robust, comprehensive access control policy, which required all employees to create robust passwords, complex passwords to guard against brute force attacks and so on. So on paper, that policy was very good, but nobody implemented it. One of the employees had password as their password. I mean, the word password as their password. And of course, this organization suffered a major data breach because of that. So on paper, they had the policy, but they did not even implement it or monitor the implementation thereof. Thank you.
Thank you very much, Advocate. So, what I'm getting from all the panelists on what is it that they strikes out to them when they come in an organization is about the low-hanging fruits, about compliance. As we know, this journey in data protection, not many jurisdictions have been doing this for a long time. It's something that is, one is data protection all along, but when the laws that require enforcement and application of these laws in most jurisdictions are fairly new. And what I understand is, from what the panelists are saying, is that let's look at low-hanging fruits. Is there privacy notice displayed somewhere? Does the security personnel understand why they're collecting information? And simply, as some of you might know, I work for the Zimbabwean regulator, and when I go for an inspection, I always ask the DPO or the organization, why would the security personnel allow our visitors to write their own names in the register, especially where this is the blanket one, whereby you will see the information of the other people who've entered before you. If you are clever enough, you might be able to memorize some of the details that are entered in that register, which in my case, in my opinion, might be minor data breach. But thank you very much for that question. I would like to welcome Mr. Lourinho from Mozambique. Say thank you so much for joining us. We are so grateful to have you on board. Maybe I'll just give you 1 minute to introduce yourself, where you come from, or that you work for, so that we can be up to speed with the other panelists. Over to you, sir.
Thank you very much. My name is Lorin Sheman. Sorry for joining late. I had some technical problems. As I was saying, my name is Lorin Sheman. I'm the chairman of the board of the National Institute of Information and Communication Technology. That's the ICT regulator in the country, but we are also acting as the National Data Protection Authority. And our work so far, we've been we're introducing activities as Data Protection Authority, and we're here in this workshop, in this webinar, to learn from other countries and share a little bit of what we've been doing so far. We just completed the first exercise that we're supervising or outdating the elements that include also data protection, and also finding out if the entities in our country, like banks, public entities, if they have data protection officers, because that's required by our electronic transaction law. This is what I can say now for this first minute. Thank you for the attention.
No, you're welcome. You're welcome, sir. It seems that you've already started doing the work, and you seem to have started on a very good note. And well done on what you're doing so far. So we're now moving on with our panel discussion, and I would want to go back to Advocate Pansi and just ask to say the POPIA, which is the primary legislation that regulates the person of personal information, emphasizes accountability as a condition for lawful processing. In practice, where do organizations misinterpret this obligation? And I think this is a very common principle that runs across many acts. For example, in Zimbabwe, we also have such a principle. So, Ma'am, Advocate, maybe you can explain to us where organizations do misinterpret the issues of accountability as a condition for law processing of personal information. Over to you, Advocate.
Accountability is an all-encompassing condition, because you can only come to the conclusion whether accountability has been complied with after you have assessed all the other conditions or compliance with all the other or conditions. It's then that you can come to a conclusion that there's compliance or non-compliance, because if there is non-compliance with one of the conditions, then it means that accountability has not been complied with. But I would like to give this, to answer this by way of examples, because I think if we give examples, it becomes more concrete. The misinterpretation that we have seen, and I'm not sure whether it's a misinterpretation or it is just lack of understanding. It comes, or different interpretations, and it comes to the condition of consent when it comes to processing of personal information for direct marketing purposes through electronic communication. It's a big issue in our country, where people get these unsolicited telephone calls to market goods. And what we see, not, what companies are doing, including the direct marketing sector, is the misinterpretation of the condition of consent. Because in our law for direct marketing through electronic communication, the data subject must consent to the processing in advance, which means that the first telephone call that the data subject must receive should be the one that asks him or her whether they are interested in receiving direct marketing messages. If they say no, then that should be the end of it. And how companies or responsible parties, as we call them, have interpreted this, they've interpreted this as an opt-out process. And if the law requires consent, it means that it has to be an opt-in. So that's where we see the misinterpretation, and also where we see problems is that companies or responsible parties do not, if they can't produce evidence of the consent that they have received, because consent has to be received in a prescribed form. They cannot even demonstrate or give us a database of those data subjects who have withheld their consent. They can't give us a database of data subjects who have withdrawn their consent, because they misinterpret this consent in direct marketing through electronic communication as an opt-out process, and whereas the law requires opt-in. I don't know if this makes sense. Am I still there?
Yes, you're still the advocate, and yes, you're making a lot of sense. We are following. I like the fact where you said compliant accountability as a principle is all about following the law in itself and how you then zero it in on the concept of consent. To say when you are doing direct marketing, the first phone call that goes out to the client, they must seek for consent first, so the client can give consent and everything else, and they should be able to have in what I call it a request register, that they keep, whether there was a consent requested, there was a consent withdrawn, all of those things that show that the data subject rights are being enforced, which goes on to say that when you uphold the rights of the data subjects, you're also being accountable, isn't it?
Definitely. And you see, even if they call you, because consent is defined in the law, it has to be explicit. You must know as a data subject what is it that you are consenting to. It cannot be general consent. It cannot be implied. You have to know, if they say they want to direct market, they must tell you what is it that they want to direct market to you. They must tell you how. You must also agree on the types of communication channels that they must use to talk to you. But that does not apply, in this unsolicited direct marketing. It's a free for all in my country. I don't know how it applies in another country. And the problem maybe is because, there is a debate on whether a telephone call, it's an electronic communication. If you receive a call where somebody wants to direct market things to you, and maybe this is one of the issues as the regulator that we will probably have to approach the courts in South Africa to assist us with the interpretation of what constitutes an electronic communication.
Well, that's amazing, Advocate. Thank you so much. Thank you so much for that contribution. I'll move on to Mr. Baker and just say, building on what Advocate Pansy you said, you understand. I understand that under the Uganda's Data Protection and Privacy Act, accountability is closely tied to registration, reporting, and oversight obligations. Where are organizations most procedurally compliant but operationally weak in Uganda? So, Advocate Panzer tried to tell us how the data controllers misinterpret accountability as a principle. So, we want to know from your perspective and from your opinion in Uganda, where most organizations are procedurally compliant but operationally weak in terms of their accountability to the Ugandan law. Over to you, Sebeka.
My Baker had lost had lost connection. Switzerland. You'll be glad to know that even in Switzerland, the Wi-Fi is bad. It keeps on connecting on and off.
No, that's okay, Advocate. Yes, you are back, and we thank you so much for the contribution. And now we are given the chance to Mr. Baker from Uganda to also then answer the same question that you did answer very well.
Okay, thank you. At least I can confirm for now the internet is good in Uganda. Now, the question of accountability, what we are seeing them, the different organizations do, but operationally seeing something different in respect to exactly what it entails. One is that at least most of them are registering. So far, we have about 11,500 organizations, data controllers, and processors collecting and processing personal data of Ugandans registered. So many of them are registered, though a lot more need to be brought on board. And then the other way we are seeing them comply with this obligation at that level is in respect to the reporting, like you've indicated. In the Ugandan law, once you're registered, you're required to file an annual compliance report between the period of July to September of every calendar year. So they've been filing these annual compliance reports, and clearly in regard to demonstrating accountability at that level, they've been doing. As part of the registration at renewal, they are required to submit policies, specifically those of information security or a data protection and privacy policy and they've been doing it because a certificate actually can be issued without having one. But that is also creating a very big risk. Many of these organizations, be it those large-scale data controllers or processors, are treating compliance and generally accountability as a state. So you'll find they are taking it as a tick box process. We've registered, or if we have registered, we've actually renewed our registration, they tick the box. We have a data protection and privacy policy, that's another box ticked. Have we filed our annual compliance report? And they will take it that this is done. But that is not what actually accountability should look like. It's not a state. When we approach the organizations, whether through creating awareness, and they tell you, no, we've been compliant for a number of years. Talking about compliance in past tense, it's not a destination for you to say that you've actually become compliant. But actually, what would be something that will be able to tell that beyond the tick box that you've been able to do? Yes, it's good practice, you've complied with some obligations of the law, but we want to see more to be done. And this is about change of behavior. So one, even going beyond the accountability, those decisions, if the organization is automating its processes. They used to collect data before using physical forms, say receiving applications of job applicants. One position and you have over 100 applicants applying for one. So those in charge of recruitment definitely will take them a lot of time to sift through and come up with a shortlist, say, of about 5 people and the competent ones. So the decision to go online and use artificial intelligence, whereby that decision now of shortlisting can even be done in a matter of minutes, was the data protection officer involved, because this is an element of collecting and processing personal data, and where actually risks around the freedoms and rights of the data subjects could actually be impacted. So in that particular scenario, was accountability now in practice part of the behavior? And decisions were made based on that. And even beyond just giving an example of that, yeah, there could be now very many organizations are doing a lot of outsourcing. So you'll find a company, they have few resources, because when you employ an individual, you need to pay their social security, you need to pay for their gratuity or bonus. But when you have a company that you've outsourced to, all you have to do is to pay a particular fee, and then they handle the processing on your behalf. So many tell us that, we've have all the processes in our organization, breach handling and all that, but they never take care of that third party. And that has been a very major source of risk. Actually, most of the investigations, when the office had just been started, it was around that. So you realize that accountability, they've demonstrated the first part, they have the documentation in place, but when you look at the behavior, it does not tally to what they've committed to. And it creates a lot of risk, not just about the data subjects, such as the clients that they serve, but even employees. And we've seen this in some of the organizations that we've interacted with, wondering that even the employees that we have, these policies that we are developing, or even the data protection that we are looking into, does it even apply to the employees? Us as the regulator, we are shocked, because we know the law is very clear on who it applies to. But it leaves us concerned if someone believes that they are demonstrating accountability, but the behavior doesn't speak to it, because even employees are data subjects. And I'll end with on the topic of data subjects, where even the courts of law in Uganda, they've come out to interpret the law. We have a case where it was a fuel station, and one of the employees, the pump attendants, they needed to use her image for advertising. So all they did was to request her to turn up smartly dressed. They didn't even explain what the data would be used for. They just told her, we needed you to turn up. Took her photo, and later it was used to advertise and market company products. So in courts, she took them to court, and court interpreted and told them that yes, consent was needed to be obtained, and not even just any consent, but valid consent as defined in the Data Protection and Privacy Act. But the interesting thing in that case is that this particular organization had elements of accountability. But when it came to the third parties, when they were getting their data, they actually had a proper process of documenting and signing a contract, which was not the same for employees. Thank you.
Thank you very much, Say. I think that was a very insightful contribution. And what I did understand from your presentation is that it's beyond the tick box. When they submit an annual compliance report, and what the regulator wants to see is that beyond what you've ticked to have done as part of your compliance measures for the year, is it there's something that is found on the paper and it's about the behavior? Does the behavior represent what has been posted? I'm also going to pause. I'm also going to be reading some questions from the chat, but maybe for now, before I read the questions from the chat, I would want just to ask to pose the question to the other panelists.
Alan, we can't hear you. I don't know what has happened.
Sorry,
You just disappeared.
Sorry, so network sometimes can play tricks on us. So maybe I'm just going to ask this to Mr. Lourinho from Mozambique, a question that has been posted on the chat box. We says, please, how do you decide to do an audit when you want to audit an organization? And when is there a routine, or do you want the organization beforehand, or you rely on the element of surprise? And I would also ask the other panelists to also comment on this question before I then proceed to ask the other questions on the question list. So please, Mr. Lourinho, take away the questions. Over to you, sir.
Thank you very much for this question. As I mentioned, we in Mozambique were in the early stage of conducting audits. We have conduct the first supervision exercise. So in that one, we selected a number of entities, close to 200 entities, the different economic activity areas that we think that are relevant for data protection at this initial stage, like a banking sector, tourism, the hotels, telecom companies. So we are in a stage where we're conducting what we call didactic auditing. So we'll go through all what is written in the law to find out how the entities or the companies are fulfilling. So in the next stage, what we'll do, we'll select the company to be audited based on their scoring in this initial supervisory exercise. Those who have lower scores are the ones that will be visiting, but not with the purpose of punishment or applying the fines that in the law, but of interacting because we're in this initial stage in this first year to educate the society in general, but in particular the companies, and they find out how are they complying with the law. So this is the procedure that we'll be using so far. Maybe in the coming years we can have surprise visits or those entities that are reported, because we're receiving report from the citizen complaining about the breach to their data. So those are other companies that will be visiting. But to make the summary of what we've been doing so far is that it's based on our list that we elaborated based on the information that we collected in the previous 1 or 2 years. But from now going on will be based on the feedback that we'll get from the companies in terms of their scoring, but also on the reporting that we'll be getting from the society.
Thank you very much for that response. Advocate Pansi, Mr. Baker, Mr. Likando, would you want to jump in on how you conduct an assessment? Is it an element of surprise? Do you notify them first? Or how do you go about it? So anyone, Advocate, I see you are already unmuted. Please go ahead, and Mr. Likando will come immediately after Advocate Pansi.
Yeah, ours is very formalized, the assessment, and it is very, it can lead, it has consequences for non-compliance. If we conduct an assessment, which we can conduct it on our own initiative or on request, and if we find that there's been non-compliance, we can issue an enforcement notice, which is binding, in which we can even fine, the responsible party. And that's what happened in the Department of Justice case, because what happened there is that the Department of Justice had suffered a major data breach. And we informed them, because you can't take them by surprise because of the legal consequences that arise from the assessment. You have to write to them and tell them exactly what is it that you are going to assess, so that they can then prepare themselves. And after you do the assessment, we normally compile a report, a preliminary report, which we then give to the responsible party to comment on the preliminary report. And then if the comments are valid and they have substance, we take them into consideration. And then we then compile an assessment report. And the assessment report is an equivalent of an enforcement notice. So because of that, we cannot have an element of surprise. But what we have done from late last year, because the formal assessment takes a lot of time and a lot of resources. So what we then decided to do is to do some informal assessments, where we do a desktop sort of assessment, where we send a questionnaire to the responsible parties on the compliance, and then we can then inform them where they fall short of the compliance. So that's the informal one. But the assessment in the law, as I've said, it can be a surprise, because the outcome thereof has legal consequences. Thank you.
Thank you. Mr. Likando, please take it away, sir.
In the case of Zambia, it's equally quite formalized. Firstly, our act mandates that audits will be done annually. So that in itself does not catch anyone unaware, because they are taught right at the time they're registering that among the things that will be done on annual basis is an audit that will take place. But the other things that really guide us in conducting audits is that we've looked at, for instance, sectors. We've looked at sectors which we feel that they are much riskier. In this case, in our case, we've isolated those that are in the financial sector and in the health sector. These are the ones that we are insisting on audits in this year, that will begin audits. The other things that also drive us to audit an institution is where a breach has been reported and it has been brought to our attention, and then we feel that even if yes, it could have been contained and everything is in place, we go ahead and also now proceed and carry out an audit. Added to that, also within the commission, we carry out compliance visits. Out of a compliance visit, this may arise because of maybe some information that we've received from a data subject about something that is happening in a certain institution, and on the basis of that also drives us to proceed and conduct audits. So basically, those are the areas that make us, or elements that make us go into audits as far as Zambia is concerned.
Okay, thank you very much, Mr. Baker. In a minute, we are running out of time, but it's an important question that I would want to get a perspective from all the panelists. So how do you go by your assessment, do your assessments and audits?
Being the last, it has been covered. We don't reinvent the wheel. We also don't conduct surprises. So we pretty much do what my colleagues in South Africa said and Zambia. Thank you.
All right. Thank you very much. So I would just so in Zimbabwe we did come up with a compliance assessment guideline where we said we've got 3 types of assessments that we do or audits. We've got a voluntary assessment whereby a data controller can write to us as an authority to say that we have been implementing these measures. Can you please come and do an assessment on our part so that we are able to see if we have improved. We also have what you call a routine assessment, whereby as an authority we plan ahead on a schedule of organizations that we're going to carry out assessments on, based on certain trends and information statistics that we've received in the preceding year or during that year. And then we also have what is called an ad hoc inspection or assessment manual audit, which is mainly triggered by an issue. Maybe there's a report about misuse of personal information, or maybe there is any information that triggers us to do an element of surprise on the data controller to understand how they are faring. And I think so. We might have, what I'm discovering right now is that we are taking a different approach as a nation. So to our panelists, as we move on to the organization, I want to let you know that we are behind time. So when you get a chance to contribute, just try and give us the key points. You are doing an amazing one and just telling us very important points, but we also want to hear more from you and ask more questions within the time that we have, so that we don't have many people leaving the webinar. Otherwise, we are appreciating the response that you're giving us. And I'm going to ask, I'll start with Mr. Likando on this question to say, when you carry out your audit, so we're just talking about when the audits are carried out, or in experience with enforcement, what are the most common red flags that you can pick that will tell you that the DPO is merely a figurehead, and rather than someone who's still operationalizing accountability? How can a DPO ensure that they are not just figureheads? What can they do so that they are really doing the work? They're really practice practitioners? So you can start say, and then I'm going to ask this question again to other panelists, but like I'm pleading because of time, I would also want you just to quickly tell us your perspective. Over to you, sir.
I think one quick aspect that tells us that there is a problem is the interaction that is there between the DPO and management. For instance, you're able to tell from the onset the level at which the DPO is operating. If the DPO is operating at a very low level, already it's a very, very big red flag, because it means that even the level of resources that are being given to that DPO could be very, very low. So that itself is a very, very quick red flag that we look at. Of course, we look at the other things which they may claim that they've put in place. For instance, issues such as policies. Policies, they may just be on paper, but for us now the issue is that to what extent have they been implemented? It's not just a question of having something on paper, but to what extent has implementation taken place? So those are some of the very quick items that we look at when we start the audit. Of course, it's guided by a very, very robust framework, which we share with them before we even move in. And on the basis of that, we'll be able to tell that there is something that is not correct or that is correct.
Thank you very much. Say, Mr. Becker, do you want to join in? And after that, Advocate Pansy, and then Mr. Lourinho will conclude.
Thank you. On our end, we start with the registration data, where we look out for, one, if they told us that they transferred data to certain countries, and if they did an adequacy assessment. So we check with what they told us at registration vis-a-vis what we find on ground. Usually that is the very first red flag, even before you go into all the other processes. And that informs the more documentation we look out for and who to talk to. And that's why we always push for registration, because we believe it's what we usually start with. Thank you.
Thank you. As I've been mentioning, the information that I'm sharing is of the only exercise of the inspection exercise that we conducted starting last year, and we just completed in March this year. According to the report that we got from the DPOs of the institutions that we have visited, that there's a lack of knowledge from the top management down to the technical personnel on the importance of the data protection. So many of the entities that we have interviewed They don't have DPOs designated. They don't follow what is been established in the law. And the main reason from our inspectors or DPO, data protection unit office here, is that the top management of the organization are not aware, and there's a need of enforcement of the aspects that are part of the law when it comes to data protection. And our following activities will be targeting these aspects before we go to fines that are included in the law. So we're working to design activities for sensitization to make sure that the organization are aware of the need of compliance with these legal instruments that are part of data protection in Mozambique. Thank you.
Yes, go ahead, advocate.
Yeah, you see, with us in our law, the information officer in a public sector are appointed by operation of the law. What I mean, if you are a permanent secretary, you are automatically an information officer. In the private sector, the information officer is the CEO, the chief executive officer. The first red flag is non-registration of the information officer and deputy information officer, because the law is very clear. Before they take up their duties, they have to register with the information regulator. So when you find them unregistered, that becomes your first red flag. The second one is when you see that the information officer here is a figurehead because he has delegated all the functions to the deputy information officer, that also becomes a red flag. And he comes as a figurehead to just give, if there's an assessment, overall political speech, and then leaves everything to his deputies. That also is not good, because the tone has to come from the top. And I think that's just one of the red flags that I can point out to. Thank you.
Thank you very much for the responses that you've been sharing. And I think the important thing is that it is important to ensure that for South Africa, there's registration, and for other countries, we are looking at the relationship between the DPO and the management. And maybe I can move on to the other questions. So the other question that we have received here is that how do you ensure accountability in the informal sector or in the low digital environment? How can you ensure that there's accountability in, for example, the informal sector or low digital environments? And I can maybe add on to say with the small to medium enterprises, I'll give a quick call is that, like, for example, in Zimbabwe, our economy is highly informal, and most of the organizations operating within our context are small to medium enterprises. So how would you ensure accountability in such a situation, and also drawing from your institutions? So for this one, I'll start with Mr. Baker. I'll go on to Mr. Likando, Advocate Pansy, and Mr. Lourinho, you the last one to conclude on this questioning. Please take it away.
That's a very big challenge because, one, these MSMEs, they usually don't have resources to support compliance. But on our end, we've been intentional to develop documents and tools to support their compliance journey. Because if you ask, I'll give an example, you have mobile money agents where individuals can go to deposit and withdraw money. So it's usually a one-man company. So asking for a litany of all the other documents and processes, it will be cumbersome to them to even ever implement. So we've developed a compliance toolkit that we are now automating on the different areas that can support them. And the second one is mainly to encourage that if someone has a company, an MSME, micro, small and medium-sized enterprise, and they do not have the skill of a data protection officer or even hire one, we are developing and encouraging what is called DPO as a service. It could be an outsourced one. They don't have to have the person on the payroll, but they can actually call on them, and they have the processes set up. So it's to also ensure that even those people that provide such a service, we do quality assurance and developing guidelines on the same. So that's how we balance it to ensure that even the MSMEs can actually be supported with complying with the law without necessarily having all the other obligations set out to them as it would be with the big data controller processor. Thank you.
I'll add on to what Mr. Baker has just mentioned. One of the key challenges that we face as regulators are the numbers that we need to regulate. They are in their hundreds of thousands, and that itself poses a serious challenge. For Zambia, what we've done is that we don't see so much risk in the SME or micro with the micro entities. Therefore, our attention mainly has been with the areas or entities that really we see that there's a lot of risk. And I think after we've done that, that's when we may now move on and see how best we can ensure that there's also accountability in relation to the SMEs and the smaller entities.
Thank you, Advocate Pansy.
I mean, our situation is same as Mozambique. We go for the big fishes, the big fish. So I beg your pardon. That process a lot of personal information and that monetize the personal information. Our resources are limited, so we can't be all over. So we haven't really looked at SMMEs. We go for the big ones.
Thank you. In our case, we are following the same approach. Our focus are on the major big companies. That's for us to consider the major risk for a significant percentage of our population. This is the structure that we'll be following, and we've been moving top down. And we think that only in the coming years, we will be focusing on the informal sector. The other reason why we are not going for the informal sector now is that we are relating this with other registration of companies. And we are using the database of the companies that have already been registered and to provide and collect data of the system. But a lot of informal sector are not formally registered in any of other economic sector regulators. So this is additional challenge. So what we're trying to do from our perspective for this sector is to dedicate effort on education and sensitization and not on auditing. Maybe in the near future we'll be focusing on auditing. And the reason why we're not going to audit is the numbers also. Because when you go down to SMEs, the number grows exponentially and we don't have resources to cover all of them now. Thank you.
Thank you very much for answering that question. So maybe the trend that I'm picking from three regulators, that's South Africa, Uganda, and Mozambique. Sorry, South Africa, Zambia, and Mozambique, is to say there is no room to go for the smaller fish at the moment because one of resources, and it is an compliance maybe trick to say that if you go for the big organizations, when they're compliant, it's easier to hold smaller organizations to compliance. I'll move on to ask another question. So we are left with about 9 minutes to finish our webinar. So in these questions, I won't be asking each and every panelist to contribute, but rather I'll have two panelists contribute per question, and then I have the other ones answer the other questions so that we try and learn as much as we can from you. Otherwise, the insights that you are getting from our panelists are very insightful and very, very, very educative. So the question that I'll ask, this one I'll give it to Advocate Pansy and Mr. Baker to say that regulators often ask for evidence of accountability. In your experience, what are the most common types of evidence that organization failed to produce during an inspection? What would you consider a minimum viable audit trail for a mid-sized check? I'll take that again. Regulators often ask for evidence of accountability. In your experience, what are the most common types of evidence that organization failed to produce during an inspection? And what would you consider a minimum viable audit trail for a mid-sized fintech organization? So it is for Mr. Baker and Advocate Pansy. So either one of the two can take the floor and answer that question. Okay. Yes, ma'am. Go ahead, Advocate.
You know, the the challenge that we have is that we're asked to say which questions we're going to answer. So that is why maybe you find that there is. But if I understood your question very well, is that one of the issues that we come across is lack of understanding and lack of knowledge of the law, particularly in the public sector. That is very common. In the private sector, you find that a lot of resources are put to bear to give people information. So you also, as I've said, that you find people who perform their duties as deputy information officers and information officers without being registered. That's also is another problem. And then another problem that, and I'm just answering the question that I prepared, I'm not sure whether it's what you're asking. Another issue that we are finding is that law enforcement agencies would want to say that POPIA does not apply to them. There is an exclusion, the Section 6 exclusion, simply because they process information for the purpose of detecting or investigating a crime. And whereas the law is very clear, you can only be excluded if the issue of personal information. And we've had a practical example of that where we investigating violation of POPIA by police, and they wanted to say that POPIA does not apply to them because they investigate crime. And we said, no, if you say so, produce a law that you have within the police services that provide adequate safeguards, and they couldn't. And that was the end of the story. I'm not sure. And another issue that I think is a problem in all sector is lack of resources. The public sector does not allocate enough financial and technical resources for compliance. That we see as another big challenge. I'm responding to the question that I was asked to look at.
No, it's okay, Advocate. No, there are no worries about that. I think these questions that we're now putting across to you were questions that were coming through in the chat box from the participants. But thank you very much. I think you did address the question in that some of the issues or the problem that you might face or that you might discover from organizations is the finance or resources tied, that organizations without resources, sometimes they're unable to have enough documents or to provide enough evidence to show that they have been demonstrating accountability. So maybe because we are left with 4 minutes, I won't ask the other questions, but rather what we'll do is that we'll have a follow-up to this, and maybe we'll write these questions to the panelists, and then they can give us some answers which we can give out to the participants. But maybe as we are wrapping up this webinar, I want to ask a general question to all the panelists so that you can give us your this, and this can be part of your parting words. What advice can you give to DPOs on how to engage and how to ensure that their organizations stay accountable? So that would be for the DPOs that are in different organizations, and I'm sure you've seen from the that we have different DPOs in different jurisdictions. But it would be important just for you to say what advice, how do they ensure that their organizations stay accountable? So these are, and then as you answer this question, maybe you can also then give us in a sentence your parting words, and then we wrap up and conclude the webinar. So maybe we'll start with Mr. Lourinho, then we'll go to Mr. Likando, then Mr. Baker, then Advocate Pansy will be the last one to speak. So Mr. Lourinho, let us take it away, sir.
Thank you very much for that question. We think that the important element to take into account to address that question, first, it's awareness, that people are aware of the laws and what is specified in the laws as part of the responsibility of the entities when it comes to data protection. Because we're finding that there are a lot of institutions, they are not aware of their responsibility when it comes to data protection, although those aspects are explicitly mentioned in the law. So we think that the training and awareness would be the first one. The second is that we find out that there's a mismatch between these functions, because a lot of DPOs that we find in the organization have training on the legal aspect. They are good in writing policies that address the legal aspect. But when we are trying to find the link and production of evidence, they don't talk and they don't have a common language with the technical experts, the IT experts who are developing and running the application. Sometimes we are finding organizations that have good policies, but when you assess the system itself and you talk with the technical personnel, they are not aware of the technology, and sometimes they don't even have as part of their policy in the developing, contracting, and running the system the importance of being aware of of data protection. So I think that it would be important that across the chain of the entities intervening up to the top management, the organization is aware of their roles, duties, and responsibility when it comes to data protection and comply with what is explicitly mentioned in the law. Thank you.
Thank you very much. Complying with the law is very important. That's a good takeaway. Let's go, Mr. Likando, Mr. Baker preparing, and Advocate Pantu finish. Please let's be mindful of time. Thank you.
Thank you very much. I think one quick advice to the DPOs. I think it's important that they keep reminding management and the staff in their institutions about, one, the consequences of not complying. That the consequences are not only follow the institution, but they will follow the individual as well. And added to that, it's also reminding everybody about the risks that we face today, which were not there many years ago. Thank you.
Thank you very much. Seb Baker and Advocate Pants preparing to conclude.
Thank you. Driving accountability in an organization is making sure that the policies that you have come to life. We encourage the data protection officers to stop drafting generic policies. What I mean, and what I'll conclude with, is that in the policies, remember, they are to guide an organization in compliance with the law. And as part of that compliance, ensure that the reports, in Uganda's case, the annual compliance reports that they submit, they are actually considered by the board. Within those reports, you include your challenges and the support that your board needs of you. That way, the board can drive compliance from the very first, from the highest of levels. Thank you.
Thank you very much. And last but certainly not the least, Advocate Pansy, you can conclude by your advice to the GPO.
Sorry, I don't know what's going on here. Yeah, let me answer this question. I now see the question that you're asking me, and I was not seeing it in the chat, and I'm feeling very bad. To say evidence of accountability, most common types of evidence. I think a PIA, a personal information impact assessment, is very, very important. And I needed to say that. And if there's no PIA and you are processing new information, you are introducing a new project or a new system and you have not conducted a PIA, then there's a problem. So I thought I should answer that question because I didn't see it. Tone from the top is very important. And I think at board level, because I think what we see is that data protection, and because of cybersecurity, which is so rife, I think the tone has to come from the board level, as it has already been said. And training of staff from not only those who are at the top, everybody has to be trained. At least they must have basic, even the lower levels of staff, they must have basic information on data protection. And there has to be consequence management for staff who do not comply. I think if you don't do consequence management, then people will then not comply because knowing that nothing will happen to them. Thank you.
Thank you very much, colleagues. To the panelists, you've been wonderful, and we appreciate with you taking your time from your busy schedules to attend this webinar. And today, all the panelists that we had are commissioners or the head of data protection authorities or the head of agencies that do data protection in their own countries. And it's very commendable. This is the first time that we've had all the 4 panels that are coming at the same time. So please don't leave the stage, and please do not leave the webinar because we are about to have a final announcement from our founder, Ms. Amaka Ibechi, which is going to come on stage and give us an announcement. And from that, as the moderator, I'd like to thank everyone who did take time to participate in the survey, in the webinar, and we would want to hear from you in the chat if there's any topic you'd want us to tackle the next time we meet up the regulators or any other topics. You may feel free to reach out on our email address or reach out to us directly on our contact details. Other than that, it's been a pleasure. And over to you, Miss Amaka.
Thank you so much, Alan. Thank you so much. This has been an incredible session. And as we close, I want to take a moment to say thank you first to our esteemed regulators. Thank you for honoring our invitation. Thank you for the insights that you've shared. And thank you for the work that we will continue to do together to ensure that we drive digital trust on our dearly beloved continent. This was more about bringing clarity to everyone who has their hands in the work. Thank you.
Sorry, just trying to bring Amaka back on. Sorry for the mishap. Okay.
It appears you lost me for a second. So I was awesome. I am back now. And so thank you so much. And I hope you heard me. I was saying thank you to our regulators for all that they've shared with us. Thank you also to the to everyone who has participated here. We know that accountability is no longer about having the right document. It's about being able to defend your decisions, demonstrate your controls, and also to respond with confidence when the regulators come knocking. And that is why the role of the DPO is really critical. At DPO African Network, we're here to help operationalize data protection across the continent, where our practice meets regulations and our regulatory guidance, where we can also turn the insights that we're listening to into actions. I've got a couple of announcements for you, and you wouldn't want to miss this one. Every last Monday of the month, we have our DPO meetup. Please, if you haven't joined us, please join us. The link will be put in the chat session. Please join us. For the questions we're unable to answer today, we might be able to take them on the last Monday of the month, which is April 27th, I believe. Come in prepared. We usually have a case study where we talk peer-to-peer and really address real life scenarios. So key questions, and we've had a number of cases today. We've seen Grace, we've seen Findile and Rogers going back and forth on consent with regards to marketing. This may be a case we can open up in future sessions. So please plug in to that. And if you have a scenario that you're dealing with at work, you want us to discuss together, take out the very sensitive information, but we'll be able to address this. The next on the list, the one that I'm really excited about, is our weekly policy and practice. We wouldn't be having one this Thursday, that's tomorrow. However, next week we'll be wrapping up because the group has been meeting to discuss the Data Protection Foundation's book, which, you know, as a community, we worked together in putting together. If you need a link to that book to purchase yours, because it's all about operationalization, you will get that in the chat. For many of you, you must have noticed that our quarterly digest is not out. That will be coming out live this week. So please look out for the digest, where we share what's going on inside the network, and we spotlight a DPO. We also spotlight regulators. If you're interested to be spotlighted, or you have an amazing work that you are working and you want to share, please let us know. Our email is in the chat. Please email us. We want to amplify the amazing work that we are all doing. Next on our list is 4 certifications. While we do a lot of training in the DPO African network, we also encourage those who are interested in pursuing the IAPP certification. So if you're currently interested in pursuing the AIGP, that is the Artificial Intelligence Governance Practitioner certification, please, there would be a link to fill the form. If you've set a date in mind, we are going to be having a study group. We've had 2 study groups right now. The first CIPPE, everyone who took the exam from the CIPPE study group really passed, and we're excited about it. And so another CIPPE group is ongoing. So if you're interested in CIPPE in the future, let us know. And secondly, AIGP will be starting next week, I believe. Please fill in the form and we will invite you to join. Again, we're also partnering with an IAPP training partner to ensure that you can get discounted fee in getting certified. More details we will provide to you. Send us an email and we will let you know what the price point is in there. If you're a DPO, you're starting, or your project, your portfolio is becoming complex and you need coaching as you go along, we have the DPO Den. This is where we work one-on-one to help you think through what you should do in executing on your task. Your role is critical and we do not want you to go at it alone in isolation or just be a solo DPO. Let's work hand in hand and ensure that your success is also our success as we drive this on the continent. This is the most important announcement. If you're interested in working behind the scene with us, volunteering or helping with programming, or you've got a brilliant idea and you think, oh my goodness, why are they not doing this? This is where we want to reach out to you. Send us an email. Let us know your idea. Let us work together to achieving this dream, because this is all about our collective effort to ensure that we can grow the community, institutionalize the work that we're doing, and at the end of the day, we will all be happy for it. Again, I want to say thank you to our moderator, and thank you to our panelists, commissioners across 4 different countries on the continent. I'm just excited. I have been taking notes all through the conversation, and I hope you were too. Again, you will get a link to the recording for this. I'm going to listen to it again, and I hope you do too. We have a YouTube channel where you can also go watch the previous webinars. And with that being said, all of your support is something we're looking out for. Please continue to support the movement in any way that you can. I hope to see you all again next month for another webinar that we are creating together. So this is from me, from Amaka Ibeji. Thank you, thank you, thank you. Bye for now. Thank you.